Welcome, everyone, to Perspectives from the Bench. Today, we are going to be talking about what judges want to see. Oh, sorry, want to see you. Yes, they do. And what they want to see in pro bono volunteers in Superior Court. I am so grateful for DC Superior Court for collaborating with us on this program. My name is Christina Jackson. I'm the Executive Director of Washington Council of Lawyers. We are the Voluntary Bar Association in DC, whose mission it is to ensure that the system treats everyone fairly, regardless of money, position, or power. And we do that through supporting our legal services organizations, our policy organizations, our government lawyers, our corporate legal counsel, and our law firm pro bono volunteers. And one of the really important ways we do that now is our growing and ongoing collaboration with the DC courts. I am especially grateful to Jody Feldman and Judge McLean, who I will talk about in just a minute. But the leadership at Superior and the appeals court is unmatched in our country. And in addition, their leadership in adapting the courts to meet litigants where we are, to meet the challenges, and to meet ways in which we can increase access to justice has been phenomenal. I'm so grateful to all of you and those who aren't on this for things like developing the Access to Justice Unit, for bringing in a brand new pro bono manager, and the brand new Access to Justice Unit director. These are evidence of the ways in which our court is both adapting and being members of our community, listening to what we need, and then helping particularly those pro se litigants navigate a really complex system. We are going to continue to discuss pro bono and the courts in the two other upcoming sessions. But today we just want to sort of level set, talk about where we are, talk about the vital role of pro bono counsel in our courts, in particular in our high volume and high stakes courtrooms. I want to introduce to you two really important folks in this effort. Jody Feldman joined the DC courts as their first ever pro bono manager in 2023 after managing the pro bono program at Legal Aid DC for 18 years. Just saying those two things does not describe the depth and breadth of her dedication to our community. At the courts, Jody focuses her efforts on increasing awareness about the pro bono needs and opportunities at the DC courts, and then helping lawyers get involved. And so we're going to provide information to you about all of those things and how you can help. The Honorable Carmen G. McLean has served as an associate judge on the DC Superior Court since 2019. She currently serves as deputy presiding judge of the probate and tax divisions. She's served as co-chair of the Superior Court's Pro Bono and Affordable Counsel Committee since its inception in 2021, which has been vital in all of these efforts. Their leadership is greatly appreciated. She started her legal career as an associate at the law firm of Jones Day and was elevated to partner in 2011. And while at Jones Day, she was the partner in charge of pro bono and public service. So to say that these folks have a breadth of knowledge in all of the opportunities and all of the ways in which you can be involved is an understatement. With that, I'm going to turn it over to Jody and Judge McLean to kick us off.
Thank you very much, Christina. We're so delighted to co-host this event with you. So our purpose here today is just to make pro bono at Superior Court more accessible to more lawyers, and to let you know how vital it is to our litigants and to the court. And so that's really what we'll be discussing here today. I'm going to be serving as the moderator. We have a tremendous panel of judges who I'll introduce in a moment. And we will have a discussion for about 40 minutes, which we've taken into account a number of questions that were submitted to us prior to this event. But if you have questions during the event you want to follow up on, please type them into the chat, and Jody will let me know as they come up. She also knows what we're going to get to, so she will save me those, but send me anywhere we need to supplement to make sure that we are giving you the information you need. And then for about the last 10 minutes that we're here today, we'll open it up and you will have the opportunity to ask us questions directly if you would like to. So now it is my great pleasure to introduce to you the panel of judges who are now here on their lunchtime to speak to you about these issues. First, Judge Darlene Soltys has been an associate judge since 2015, including a number of years in the family court, where she currently serves as presiding judge. Prior to coming to the court, she clerked at Superior Court and served as a prosecutor in Prince George's County and the United States Attorney's Office for the District of Columbia. Judge Kenia López served as a magistrate judge at Superior Court since 2012 and then became an associate judge in 2022. She previously served at the Domestic Violence Division, but now serves in the Domestic Relations Branch, where she oversees contested custody cases. Prior to taking the bench, she was a bilingual attorney negotiator and worked for the Office of the Attorney General for the DC, as well as clerking at the Superior Courts in both DC and Massachusetts. She was also a prior president of the Hispanic Bar Association of DC. We also have Judge Judith Pipe, who has been a Superior Court magistrate judge since 2020. And in that role, she was in the landlord and tenant branch of the civil division. She became an associate judge early this year and is now on a felony 2 calendar. Prior to arriving at the court, Judge Pipe worked for the Public Defender Service for DC, acting as lead counsel in dozens of bench and jury trials, and also as a leader supervising other trial attorneys. We also have Judge Robert Okun. He has been an associate judge on the Superior Court since 2013, serving in many divisions, but is currently in the criminal division on a felony 1 calendar. He's also taught at multiple law schools in our area, and I have the privilege of him being my co-chair on the court's committee on pro bono and affordable counsel. Prior to arriving at the court, Judge Okun tried and argued cases in various trial and appellate courts as an AUSA and other government roles. So with that, I'd brag on them more, but I want to save our time for the reason that we're here. I'm very honored to be their colleague. But so to kick things off, we have representatives from a variety of areas at the court where there is a huge need for additional pro bono counsel. These aren't all the areas, but these are some key areas. So to kick that off, I'd like to hear from Judges Soltys, Seoane, López, and Pipe about typical cases in their area of experience and the roles that pro bono lawyers play. Judge Soltys, will you talk to us about child custody cases in the domestic relations branch of the family court, please?
Sure, I'd be happy to. I'm really happy to be here to try and beat the bushes and encourage people to take on opportunities to volunteer. You know, we have so many unrepresented litigants in family court. I was a prosecutor my entire career, and I always had opposing counsel. So it was a real shock when I got to the Superior Court and was assigned to family court and had so many cases in which it was just 2 parents fighting over custody of a child. And there was nobody else. Nobody had a lawyer. There was no guardian ad litem. So something that is incredibly valuable in the family court is when lawyers who work at private firms volunteer their services as a guardian ad litem, a lawyer who represents the best interest of the children. And they can either go through DCVLP, which is the DC Volunteer Lawyers Project, or CLC, which is the Children's Law Clinic, where they get a lot of training. And then they come into court and they make recommendations to judges about how custody should be shared between the parents. And they've done a lot of legwork with talking to various family members and teachers and doing a home study, that sort of thing. And I can't tell you, their participation is invaluable because I sit there on the bench and I have no idea whether or not these parents are telling me the truth or what's really in this child's best interest. And we're just grateful every time we have lawyers that are willing to take time out of their busy schedule and volunteer and represent kids in custody cases. So that's my spiel. I've got another one when we come back. When you circle back to me, I've got another story to share with you.
Thank you, Judge Soltys. Judge Seoane López, can you talk to us about the civil protection order cases that you heard when you were in the domestic violence division?
Sure. Thank you so much for having me. So great to be here with all these wonderful people. So I served in the Superior Court's Domestic Violence Division, and like Judge Soltys, many other people are also unrepresented. They're victims of domestic violence. They come in usually and file for a temporary protection order on the day that they file their petition. Those cases are heard on the day of, usually by one party is there, the other party has not been served. And the court will hear whether a temporary order is needed for 14 days. Cases are set for trial 14 days from that date. And so it's really a great opportunity for lawyers who may not have a lot of time to actually help out a party, because the system is designed to make it really quick in terms of the turnaround, but also like the trial dates. The goal is to get to the trials as soon as possible. And so most cases are actually resolved on the day of trial, 14 days from the initial filing, which really makes it doable in terms of the time constraint. But also the Domestic Violence Division is very friendly for virtual hearings. And so most lawyers that volunteer don't actually have to come to court and can be at their desk as they're meeting with the attorney negotiators on the day of the hearing, and then waiting for the hearing for the case to be called. So if you could still be in your office doing some work in between while you're not needed. But it really does make a huge difference to have someone there who can explain the process to the litigants, because it moves so fast. And they don't have any idea what is happening. So those are ways that you can help in the Domestic Violence Division, by helping the parties to either file for, some of them file for a temporary protection order, and they are actually handwriting their petitions and alleging intrafamily offenses as best they can, because they're not lawyers. And so it really does help to have a lawyer when they enter the case to look at the petition to make sure that they didn't leave anything out. If they wanted to add more things in terms of more allegations, and they can do that before the trial, so that we are having a better trial based on the allegations that the people want the court to hear. But oftentimes we have to continue the case for allegations to be either added, because they start telling you evidence about something that's not really in their petition, and the other person really had no notice that they were going to defend against allegations on different days, even sometimes different years. So that is helpful too, to have an attorney kind of look at the petition for request for a civil protection order. Also, these cases deal with what Judge Soltys was just talking about, a lot of parents, a lot of kids, and there's also the opportunity to kind of follow that case to the family court. If you are inclined to do so, you can help them file a custody case that would be a more long-term custody order in the family court. So there's a lot of opportunities to be engaged for a short period of time, but also if you want to keep working with the family if they have other needs in the court. Thank you. I won't take any more time.
No, thank you very much. Judge Pipe, what do typical cases look like in the landlord, tenant, and housing conditions branches of the civil division?
Right. Good afternoon, everybody. I'm also very excited to be here and encourage you to donate your time to Superior Court. I know your time is valuable, and I'm so glad you're here and interested. I am currently in the criminal division. As Judge Soltys mentioned, we're kind of spoiled here because everybody has lawyers. But I spent the first half of this year in landlord tenant, where half of the parties always have lawyers. The plaintiffs or the landlords virtually always are represented by counsel because they are corporations, but the tenants are almost never represented. We have amazing legal service providers, and they do everything they can, but they have limited resources and limited staff. And I can't tell you how excited I and every other judge who sits in L&T was when we saw a lawyer come in with the tenant, because what we want to do is make the right decision and apply the law to the facts. But we only know the facts that we know, and we do our very best to elicit from the tenants in front of us on very high volume calendars the relevant facts. But we cannot do what you all can do if you can meet with a tenant, sit down with them, figure out what their story is, any potential defenses they have and what the relevant facts are, and then present them to us. And then we can make the correct legal decisions. So it is invaluable to me when people come in. And so in L&T, it is all eviction proceedings, the landlord-tenant specific branch. So it is a landlord seeking to evict a tenant. And so it would be representing the tenant in avoiding the eviction. In housing conditions court, it is actually the tenant suing the landlord, saying that these conditions violate various rules and seeking to fix those. And so you can represent tenants in both of those forums. And I'm excited you're here and interested in doing that.
Thank you so much. Judge Okun, some of our attendees might be thinking that they would like to help, but they're nervous and they have no experience in some of these specific legal areas. And so are worried about how they would represent someone. What would you say to those folks? You're on mute, Judge Okun.
Rookie mistake. Good afternoon, everybody. I'm really happy to be here. I'm glad that so many people are here as well. And I want to apologize in advance in case somehow my image cuts out because I've been having Wi-Fi problems. And believe me, it's not because I don't want to be here. It's because of the Wi-Fi. But in the meantime, let me just say, if people are nervous and don't feel like they don't know enough about the law and they have questions about what to do if they get one of these cases, I would say there really are a number of places you can go. First of all, we have a number of really great legal service organizations in the city, and they can provide live training, written training. They can provide mentors. They can provide sample pleadings. And sometimes some of these legal service organizations will act as co-counsel as well. So that's one of the key places you can go if you're looking for assistance. Also, for folks who are at law firms or also some other organizations, they have pro bono counsel or coordinators. So if your firm has one of those, that's another great resource. I would also say you could ask colleagues or friends in your organizations. If it's a big organization, you might have people who've worked on these sort of cases in the past. You could team up with a peer at your organization because sometimes that can just lighten your load and it can make it easier to learn the case together. I would also say one really helpful thing to do could just be to go to court. Observe proceedings in court. All these or almost all these matters are open to the public. And if you want to get a sense of what these cases actually look like, look at them, go to court and see what one is actually like. And then the last thing, or actually just two other things. The Washington Council of Lawyers also has programs and provides training if you're interested. And finally, I just want to note on a related issue that we internally, that we as judges have been providing training to other judges so that they could appreciate that pro bono lawyers are often new to the subject matter area and the importance of us as judges being respectful of that so that pro bono lawyers will have the time to develop these cases and will have the time to develop as lawyers and keep coming back to help more litigants in the future. So those are some of the different places you can go if you do have concerns or if you are nervous about taking on one of these cases.
Thank you, Judge Okun. And we will put in the chat some specific information about the organizations that you can contact for certain areas, but we're going to talk a little bit more about that first. And of note, I think it comes as a surprise to many people that the Superior Court has no mechanism directly to manage or appoint pro bono lawyers. Nearly all of the pro bono lawyers involved at Superior Court come to the court through one of the legal services organizations that we'll be talking about. And with that in mind, turning back to our specific subject matter areas, Judge Soltys, can you talk to us about the specific legal service organizations that support custody cases and more about why that's important in the family court?
Sure. There's a lot of opportunities in family court, in DRB cases in particular, to get involved. DRB is domestic relations branch, and I'd say 80% of the people are pro se. So that's divorce, custody. It's also child support, alimony, marital distribution of debts and marital assets. And we have so many different legal service providers, from Bread for the City, Neighborhood Legal Services, DC Affordable Law Firm. The list goes on, and they've all associated themselves through FLAN, the Family Law Assistance Network. And so we're always making referrals for unrepresented people to contact the Family Law Assistance Network and see if they can find an attorney who will represent them for free. The DC Bar Pro Bono Center has a lot of opportunities for volunteers that are willing to do this. And one of the things I'd like to just share with you is how important it is, as I said, to be involved, for there to be an attorney in a divorce case or a custody case. Because like I said, you know, we're sitting on the bench and we're trying to make decisions we're trying to find the facts. We're trying to decide who's credible and what other evidence is there that corroborates what somebody has told us. We don't have an investigative arm. Like, we can't go out and do our own background on people. Like, we have to sit there and take the facts that are being presented to us. And so it's invaluable for people to have an attorney. And I want to just share one quick story with you about a divorce case where the husband came in, filed pro se paperwork for a divorce. He and his wife had been separated for about 8 years. She had left. She had moved down to South Carolina. She was working at Dollar General, where she was robbed several times and was really sort of suffering. And in his complaint, he said there was no marital property to be divided. It was just a straightforward divorce. Well, she was able to get pro bono legal service provider to represent her, who did discovery, who found out that the husband actually had purchased a home here over on Capitol Hill during the time that they were married. And he was a federal government worker, and he had contributed to his thrift savings plan. So there was a lot of marital assets out there to which the wife was entitled to an equitable distribution. And had she not had representation from a legal service provider, you know, I would have heard his testimony that there was no marital property, and she might have been left out in the cold. So the point that I'm trying to make is that these cases can be so rewarding. You know, you are giving up your time and your energy, and you're coming into court and you are making a difference, and you are helping people present their best case to a judge. You are helping kids where their parents are fighting over custody, helping their parents to come to the best decision for them. It's incredibly rewarding. And like Judge Okun said, we know that this is not your expertise. I'm always grateful, so grateful to people who are willing to serve as a guardian ad litem or to pro bono counsel. And they talk to me about what a rewarding, enriching experience it was. So it's something that I hope that you'll consider.
Thank you so much. Judge Pipe, same question for you regarding the landlord tenant and housing conditions branch.
So you're going to hear some of the same sort of organizations that Judge Soltys mentioned. So DC Pro Bono Center certainly has a lot of resources, Legal Aid DC, Legal Counsel for the Elderly, Neighborhood Legal Services Program. All of those organizations are routinely in landlord-tenant court and routinely help pro bono lawyers figure out what to do, because we all recognize that you are donating your time and this is not your field of expertise, and they will get you set up in where you need to go, what you need to do, some sort of standard motions and things that you need to know. And I just want to echo what Judge Soltys says about what a difference it makes. You know, kids and family and resources, incredibly important. In landlord tenant, you're talking about housing, and you're talking about whether or not someone is going to have a place to live or not. And we want to know whether we are making the right legal decision. And again, we just don't have the ability to investigate that. And, you know, I do my best in eviction court to say, are there any reasons that you have not paid your rent? You know, is there anything related to the conditions of the home? And I try to tick down as much as I can with the 60 cases that I have every single day. And I do my very best, but sometimes people don't even know what they are entitled to have in the home. And it is very hard, for me to explain and explore every possibility and every possible defense, but that is something you can do, and you can make a huge difference in someone's life. And those organizations are amazingly helpful in helping you do that.
Thank you. Judge Seoane López. What type of legal services organizations are active in the civil protection order cases? And if you have anything more to share about the importance of pro bono representation in those cases.
So I'm feeling so grateful that we're in this jurisdiction with so much help, but it's still, and I feel almost bad complaining about needing more, but we do, there's not enough to fill the need. And we have the same organizations in the Domestic Violence Division, IULA, Bread for the City, Neighborhood Legal Services, DC Volunteer Lawyers Project, and Legal Aid, and there might be a few more. But again, it doesn't address the need. And in terms of the family and even a divorce, really the civil protection order is really important because it could rebut the presumption of shared custody. If it goes to trial and there's a finding of an intrafamily offense, and so in cases where children are dealing with parents with domestic violence in the home, that becomes really important at the custody stage. In addition to that, we can also consider domestic violence incidents in distribution, equitable distribution of assets for divorces. And so while the civil protection order hearing is very short in duration, really the what could come out of that is really would be really helpful to some of the parties. But sometimes they don't know that. They don't know how this is going to affect the other legal proceedings that they have. And I think once you have pro bono counsel, they will be able to consider all those things in terms of how to proceed with the case or whether to proceed at all. And so it's really important. It has made such a difference. If I had a red carpet and I could pull it out every time a pro bono lawyer came into my courtroom, I would be so happy to do so. And I throw balloons and everything because it really does make a difference for the parties, and for the children who are often not able to be heard by the court. And really the guardians ad litem bringing a special perspective that we wouldn't have if they weren't there. Recently, I think about a week ago, I was ready for this motion for to modify trial, and these parties have gone back and forth for like a year, and every time they come, I have to call the security office. The dad's sister was removed from the courtroom. It was just a very nasty situation, and I had asked for a court security officer for the whole trial, which was a whole day. And the guardians ad litem come in and said, "Judge, we have an agreement." And I almost fell off my chair because I was like, "There's no way we're going to have this. We're going to have this trial." And in this case, both parents were actually the defendants because this case was started by the grandmother years ago. She's no longer in the case. And we had never been able to sit both parents together in the same table as defendants. And they came in, they had an agreement. The father looked like a different person. He was not angry. His demeanor was different. I told them that the change in their discourse was palpable, and that I've never seen anything like it. And I really attributed that to the guardians ad litem. They were like, I don't know what they did. And I'm still like thinking about it. Like, how did they turn things around? Because it was going to be a really nasty day trial. The children were recorded being at the school grounds at 8 o'clock at night, breaking into the school. The allegations that went with the father, they're not being supervised, and they were missing school, and mom was trying to have the kids during the school year, during the school days, so she can take them to school, and then dad on the weekends. And it had been reversed before. Mom used to get them on the weekends, dad had them during the week. They just came to a really fair agreement that mom will keep the children because they're doing really great at the school where mom has the children, and dad will have the weekends. And then they would split 1 week on, 1 week off in the summer. And I always say, I hope I don't see you, and I mean this in the nicest way possible. And the mom said, "Actually, you're going to see me because I'm going to law school next year." And I was like, we were just so happy. And she told us that she got into law school, and they were like so pleasant to each other. And I made some observations that, that I hope that they can continue to work on behalf of their children in this manner, and that they need to kind of tune out the noise. I told them that it was obvious to me that the families were the ones who were causing the friction and not necessarily themselves. And they tend to agree with that. And it was just a happy ending. Seriously, I haven't had such a pleasant hearing in family court or in a very long time. And I think that the GALs really did make a difference in that case. And they make a difference in every single case because we have more information to make better decisions because of pro bono attorneys in the courtroom. So I hope you really consider helping us out.
Yeah, and if there's been any terminology during this conversation that is unfamiliar to you, just imagine what that's like for people who don't have a legal education, right? We're talking about interfamily offenses. That comes up constantly in custody cases. A lawyer can look up the statute, see what the definition is, see how it's relevant to a custody case. An individual who doesn't have a lawyer probably gets a little lost in that language. And we are, as judges, it's our responsibility to make the proceedings as accessible as possible. But that's really difficult sometimes. We try and use lay terms where possible, but there are some legal terms that are just important to use. We don't always have time to explain them. These are high volume calendars. And quite frankly, we've been down 25% of our judicial staff for 8+ years. And so we are doing our best to try, but we just need more assistance. The Superior Court Committee on Pro Bono and Affordable Counsel has put together these 2 handouts that are in your chat there. One of them talks about what are your pro bono goals. Everybody can have different goals. It could be you want to get in the courtroom and develop your skills. It could be you want to serve the community members. You can read that 1-page handout and get some thoughts on how to pick a pro bono project that might fit best for you, because there's lots of different options. And then the second handout, it relates to, once you think you know sort of an area that you want to try, what organizations do you want to contact so that you can get more information about that area, perhaps get training, request a case. So I'm sure we'll distribute, Christina will distribute those in a follow-up email after this presentation, but you're also welcome to get them there in the chat. Another thing that has been very important over the past several years in these cases is the new impact of remote or hybrid proceedings. Judges, lawyers, and the litigants are often juggling many competing considerations related to work, family, getting through case dockets. So I wanted to hear from our judges on their thoughts about when and how matters are set on a remote or hybrid proceeding and the impact that may have on litigants and the ability of pro bono lawyers to take on matters.
I can say in landlord-tenant, it's been amazing to have remote proceedings. It used to be that virtually no tenants showed up in the morning and all of the evictions were granted. And now people really do show up and things can be decided on the merits. I think it's also so helpful to the lawyers. I mean, you don't have to come downtown. You don't have to park, I mean, just like the litigants, right? And it's easier for you all, but it's still, you know, if you're not used to coming downtown to the courthouse, it is not the most pleasant experience. You can just log in to the WebEx from your desk and you can do everything else that you're doing, waiting for your case to be called, and then just listen for your name and pop into the WebEx and you have your case called. And so I think it's been amazing for the landlord-tenant branch in particular. I think it's increased participation by both tenants, and I hope the lawyers find it much easier as well. Almost everyone is virtual except for evidentiary hearings.
How are things currently working in the decision making for setting hearings in the domestic relations branch?
So WebEx has pros and cons, just like everything in life. So when we first started with everything being pre-pandemic, you had an initial hearing. 50% of the cases went away at the initial hearing because either the plaintiff failed to appear, so the case was dismissed for want of prosecution, or the defendant had been served and failed to appear, so default was issued. And then the pandemic happened, and we converted to 100% remote. Then we worked on our Reimagine the Court plan when we all came back in family court in our early summer of 2022. And so what we do now is a lot of hearings start off, they're in person, but then the subsequent hearings, which are status hearings, people going to mediation, coming back, telling us whether or not they've reached agreements or not. Those hearings can be remote. And just like Judge Pipe said, the number of the level of participation has increased tremendously. And it's just so important for people to be able to log in from home as opposed to taking time off from work, finding a babysitter, taking public transportation or to the courthouse, driving to the courthouse, paying for parking, going through security, getting into the courtroom, sitting and waiting, and then doing the reverse to get back home or get back to work. It's really, it has opened it up, and it has made the access to justice that much great. I did a trial on whether or not a parent could relocate. I was sitting in the courtroom. The mom was actually in Sweden during the trial. The dad lived in Berlin, but he was in Croatia during the trial. And the mom's first witness, her best friend from DC, was in Portugal on vacation when she testified as a witness. And we were able to accomplish this trial with remote witnesses and remote litigants, and just make it that much easier. So the short answer is evidentiary hearings and trials where we're making credibility determinations are almost always in person, but so many other things are done remotely. And it is just such an advantage. It's such a benefit to the party because they can all figure out how to use a smartphone and download WebEx and log in and participate.
And Judge Seoane López, how are things handled versus remote in person in the domestic violence division?
So domestic violence, if it hasn't changed since I left, we just never knew how people would appear. They have the choice to come in virtually. Most people, I think 80% of them do. I think that slowly but surely more people coming in person. Some people prefer to be in person, and that's fine. But a majority of people are remote. They'll check in remote. And because the trial happens on the same day, and we don't know if we're going to have a trial that day, depending on what happens in negotiations, the trials are mostly virtual in domestic violence court, which is unlike any other division. And I have to say, as a judge, I prefer in-person trials. I just feel like it's so much better. But because of the nature of the domestic violence dockets, you can't just say, okay, come in now, because we're going to hear the case at 2:00 in person. So we most likely hear the cases in virtually. But there is also a combination of hybrid. Sometimes person's there and in person one party, and not just like Judge Soltys explained. And so we just work with what we have. But it's really hard to know in the morning how people are going to present, because domestic violence does have that policy where people can come in virtually if they wish. And I think a lot of people take advantage of that.
And Judge McLean, can I just jump in, because before the Wi-Fi kicks me out again, and I know I missed some and I apologize, but what I wanted to say is I've been in criminal for the last 6 years, where everyone does have an attorney. But beforehand, I was in the civil division, I was in family court, and I saw the critical need for attorneys in those courts, and I saw what a difference they can make. And so when I think about it, I like to talk about the situation where people volunteer to help out people who don't have lawyers as what a win-win-win situation.
I'm giving him, all right. So we lost Judge Okun again. All right. This is one of the things that I learned in coming from private practice to government, is that sometimes things cannot operate quite as smoothly. But while I'm talking about my experience in private practice, I did spend a good decade as a pro bono attorney and recruiting other people to be pro bono attorneys. And I will say that the hybrid nature of hearings, and almost all hearings where there can be pro bono lawyers at the court, are just going to automatically be hybrid. So even if you're required to attend in person, oftentimes you want to have a supervisor watching you so they can review you, or so you can call and ask them questions. I could see that it would be much easier to get that supervision even if you were required to be in person, or you opt to be in person as a pro bono lawyer, to be able to have senior associates or partners be able to participate remotely. And also getting yourself acquainted with a subject matter area or a judge before you're going to appear before them. You can attend hearings remotely. The courtroom clerk will often ask you to identify yourself, but if you just identify yourself as an observer, as long as the hearing isn't closed, and most of them aren't closed, that can be the end of the conversation. You don't even have to put in your name if you're not a part of that specific case, if you're just observing. So I think that the hybrid nature of our hearings lends itself so much to training and also career development, which leads conveniently into my next question for everybody. But what are your thoughts regarding how pro bono work in Superior Court can contribute to a lawyer's professional development early in their career?
So I'll go first. So there's nothing like appearing in court. And I know a lot of times, so I was at the Public Defender Service for my career before I came to the courthouse. So I was in court every single day, but I know a lot of folks, if you are at a firm or doing something else like that, you're not appearing in court every day. And there is nothing like getting into court, having a client really next to you, and it matters the words that are coming out of your mouth, and having to be able to argue something in front of a judge. That is an experience that will help you develop as a lawyer like none other. It helps you think critically about the issues and the end goal, because it all sort of ends in that culmination of the trial or the evidentiary hearing. And being able to see a case all the way through to that final litigation point, it is an invaluable experience. So I think it's really critical for lawyers to get courtroom experience.
So I'll go next. I had the experience when I was in law school of participating in a clinic, and I had a jury trial as a third-year law student. And it made me realize that I loved being in the courtroom. That's what I did my entire career. I was involved in litigation. So that opportunity to do pro bono work and be in court, it's just so exciting. I think I lived my entire life with never watching any courtroom drama TV shows, and my friends would always say, why? And I'd say, because I live it every day. It's just so exciting and interesting to see what happens. And so you learn these skills. And what Judge Pipe was talking about, you have to learn to think on your feet. You prepare, but then you have to pivot because something completely unexpected happens in the courtroom, and you have to figure out how to handle it. It is an opportunity to participate in litigation, whether if it's on the civil side. So you're learning about complaints and service and discovery and filing and motions practice. And it's a fantastic way to get the experience of seeing how litigation actually unfolds from the civil side, and then also seeing what happens in a trial. And you're, calling witnesses and you're presenting your case, and then something unexpected happens, and you have the ability, you've learned how to deal with that particular issue. It's an invaluable learning experience for people who are at any stage in their career. But like I said before, it's so exciting. It's so dramatic, but then it's personally incredibly rewarding.
I agree with all of that. And now I have my buddy here. Chambers are right next door. I'm like, just come over.
So, yeah, and I don't know where I got cut off, but the bottom line is it makes such a difference I mean, it makes a difference to the client because that client could be facing some really serious consequences. And if you get a good result, that makes a big difference in people's lives. It makes a real difference to the court because we're trying to make informed decisions, and we can make much better and much more informed decisions if we have lawyers on both sides. And this is kind of following up on something that Judge Soltys was talking about. It's really can make a difference for you as a lawyer. I mean, partly it can make a difference to you because you're going to be learning these litigation skills. You're also going to be learning the skills outside of the courtroom, the skills about dealing with clients. And that's an important skill as well. And also because you're making a difference in someone's lives. And that, I think, is why a lot of us went to law school to begin with. So I think it really is what I call a win-win-win situation. And I guess the last thing I want to say, just in terms of a specific example, many years ago when I was in civil, I had a case where someone was facing a foreclosure, and I had concerns about the case, and she did not have a lawyer, and I reached out to legal aid, and eventually legal aid partnered with a law firm, Zuckerman Spader, and they stayed with this client for many years, and she remained in her home, and eventually they got a really good ruling from the Court of Appeals as well. And I got an email from that lawyer 7 years after I appointed him to tell me what had happened in the case and what a difference it had made. And so I just want to say, like, you can make that sort of difference as well.
Go ahead. Yes.
Sorry, I agree with that. And I would add that I think something that we don't do enough and they don't teach in law school is how to be comfortable in a room with people who don't agree with you. And that person's called opposing counsel, and it's also called the judge sometimes. And so I think part of like being in court and taking on a case is to kind of be okay with having a different view of what's happening and being fine with it. I don't think that we teach that enough. And I think that's another great skill of a lawyer. It also teaches you how to be reasonable. Just because you can make every single objection doesn't mean that it's reasonable to do so. And so you don't know that until you actually practice or see it. And so I think it's important to see other lawyers and how they work as well, and to inform how you are working yourself. But being in a room with people who don't agree with you is paramount, I think, to being a good lawyer, because you have to be okay with that.
So we'll open it up to any questions that you all have, and we'll allow you all to unmute yourselves and ask your questions directly if you want, or you're welcome to put them in the chat. But I just wanted to add to what my colleagues said. When I was an associate and I was trying to get the experience that I needed to progress, I took my first deposition in a pro bono case. I argued my first evidentiary issues in a pro bono case. I took witness examinations in a pro bono case. So then when people were trying to say, hey, have you done this before? I said, yes. That was it. The answer was yes. And so it made it very helpful for me to get other experiences and to demonstrate my value to my colleagues. And from a litigation perspective, our cases are shorter. And so you can see how the entire litigation process fits together in ways that I wasn't able to see from my billable work. So, why is discovery important? And how am I going to use discovery strategically to prepare my case for trial and narrow the issues for trial? How do I want to use the resources I have, be them time or money to take depositions? And how, the strategy about putting things together, or what motions do I want to file? Is there a disputed issue of material fact, or should I file a motion for summary judgment? Just being able to understand all of those mechanics in a more finite way, I found incredibly helpful. There's also the skills that we don't often think about that are vital to both pro bono work and billable work: client counseling, talking to your client about what the law is, what facts are relevant to the law, what claims are good, what positions should you take and should you not take, and negotiating with opposing parties outside of the courtroom are all things that happen in these pro bono cases. And I will say that pro bono cases at Superior Court are not just for litigators. And our next event in this series will be with an entirely new panel of judges, and will be focused on how people who really don't want to litigate can still help members of our community through Superior Court. So we understand that not everybody wants to litigate. I don't know why that is, but we understand that to be a fact. So does anybody have questions that they would like to ask us? We've done our job so very effectively that there are no follow-up questions that I'm seeing. Jody, are you seeing any that I'm missing? Okay.
Add something in terms of like the community that we serve. There's a lot of people who are not from the United States working in court. And really, if I can have an attorney assure them this is a whole new system, and for most of them, their systems in their country are very different in terms of like the judge is the one that does the investigation, asks the questions. So some people are reluctant to answer questions from judges because they don't really understand our role. And I will pick a pro bono lawyer on the worst day than someone who's pro se, because at least you are well versed in the culture of like where people sit. Just that alone, you know, who gets to speak when and how, and just the language that we use. Sometimes we try to use common language, but sometimes you just have to use certain language and they don't understand. And I recently went through this Senate confirmation process, and I'm sitting there and my nomination's on the floor. And I'm like, what's happening? I don't know. And I didn't learn, you know, Senate procedures in law school. And so I didn't know who was talking and who was supposed to talk next and what they were saying. And it was obviously something that was really important to me in my life, what they were deciding. And I was like, oh my God, this is how the people feel in my courtroom. You know, it was really great to be in that scenario, because I really felt like this is how people feel in my courtroom. They don't know who's talking. Obviously, to me, there was like a well-established procedure about who talks when and how, and everybody knew what they were doing and they were moving along. And I had no clue what was happening. And I had to call my friend who was a Senate expert. I'm like, why is this happening? Why is the senator speaking? And he was able to walk me through all of that. And so I see the pro bono lawyer as someone who will be able to talk about that, even if you don't know every specific thing about my nomination or everything that was before the court. So just having someone kind of sit by you and talk about the procedures. For people from Latin America, we have an adversarial system. They have a very separate system, it's an inquisitorial system. And so the court's really doing the questioning and the investigation. And so it's really hard to get someone who knows that system to come into our system and understand that it's adversarial. Everybody gets a turn and the judge is neutral. So just knowing that and like being able to walk someone through that, I think it's life-changing in terms of their experience, but also yours. Because oftentimes we think that the way that we do things is the only way that we know how to do things. And you learn a lot about different cultures and different people through this process as well.
We have a couple of questions now. And so one of the questions is, does the probate court welcome pro bono attorneys for guardianship cases or estate matters? And I will say yes, 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 as a member of the probate division leadership. Yeah, I often see people in the probate division, you know, just yesterday in a hearing, they were really confused about the process. And it's the probate is a process that almost everyone has to go through at some point in their life due to the death of a friend or an injury of a friend who no longer has the ability to make decision making. So we did just this year, the DC Bar Pro Bono program, together with the Legal Counsel for the Elderly and DeKalb, I was right there, the DC Affordable Law Firm, reinstituted and created what is called the Probate Law Assistance Network. And they are on site at the court to provide brief legal advice to low-income residents. They are currently there 2 mornings a week. They're looking at adding additional time. They're also available remotely, and they will take volunteers who want to assist in full representation in a probate matter. So I will make sure that we send around the plan, nice acronym, flyer, so that you'll know the groups to get in contact if you'd like to help in a probate case. Another question that we received is there a minimum practice experience as a number of years to serve as pro bono counsel? No, there is not. Absolutely not. You know, and one of the beautiful things about pro bono appointments running through legal services organizations is those legal services organizations will either, will usually mentor you. There is one specifically that will appoint co-counsel, but usually they will mentor you. That is incredibly valuable. They will give you pleadings banks, they will give you training, they will sit down and have meetings with you and have specific strategy sessions and answer your questions regarding your specific case. So you are, I mean, if you don't have your, if you haven't passed the bar yet, you might need to pro hoc it. But if you pass the bar, you are qualified. And then the last question we have, is it easy to recover if a first-time pro bono attorney doesn't do a great job in their first case before the judge? How would the judge know you're still learning? I can tell you yes, because I did a horrible job in my first case as a pro bono attorney. It was traumatic, and I didn't realize what a horrible job I was doing until I was in the middle of doing the horrible job, and I just had to keep pushing through. But I learned from my mistakes, and I took on more and more and more cases. And then I became proficient, and then I became a mentor to others. So I firsthand, I could tell you how horrible it was, but I choose not to relive it. Go ahead, Jody.
I just wanted to add one thing about the minimum number of years. The DC courts and the DC bar recognize how important the need is to get more lawyers involved, and because of that, our ethical rules actually are quite liberal in terms of allowing more junior folks to do pro bono work. So for example, as a law graduate without even passing any bar, there is a provision, an exception to the rules, the licensure rules that allows you to practice with certain with certain factors there, as well as folks who are licensed elsewhere but not yet licensed in DC. So the liberalization of those rules is really a recognition of the value that even the newest lawyers can provide in providing pro bono services in our community.
And one of the questions was, how do the judges know you're still learning as a young junior pro bono lawyer? And I will say that's one of the things that is our responsibility, and we're taking it on our end as a part of the committee. We are holding, it's been so far, it's about yearly for the past 3 years, because we hold trainings with judges, and we talk to them about thinking about the value of what you're getting from a pro bono lawyer, while what they're providing might not be what is like a 10-year experienced lawyer. It's very valuable, and we need return pro bono lawyers. We need to be patient with folks to be able to allow them time to develop their skills. And so that's something we talk about very regularly internally. And it's something we don't have to, because so many people recognize it on their own, but we do continue to talk about that. We want to make ourselves and the court a less scary place, so that more of you will be comfortable appearing before us. But we want to be respectful of your time, and we just have a minute left. I will just say we focus on certain areas today. There's more areas. If you know what area you want to volunteer in, go ahead and contact the legal services organizations in that area directly right away. If you have questions and you want to explore and think about things more, please contact Jody Feldman. She'd be happy to do that and talk to you about the areas that we haven't talked about today. You will get a follow-up email, and I'll turn it with future opportunities, including the next 2 sessions in this series. And with that, I will turn it over to Christine Jackson. But first, thank you so much to our panel of judges for taking your time today.